calling civil matters 16-4294, Valley Indian Tribe versus Bureau of Reclamation of Department of Interior et al., and case number 16-6863, Yurok Tribe et al. Versus United States Bureau of Reclamation. Counsel, please come forward and state your appearance.
Good afternoon, Your Honor. Thane Somerville for the Plaintiff Hoopa Valley Tribe.
Thank you, Your Honor. Patty Goldman for the Yurok Tribe, the Pacific Coast Federation of Fishermen's Association, Institute for Fisheries Resources, and Klamath River Keeper. And with me at counsel table is my co-counsel, Stephanie Tsosi, and also with the Yurok Tribe, Amy Cordalis, Daniel Cordalis, Dave Hillemeyer, and Michael Belchick. And I'd also like to recognize in the courtroom we have 3 tribal council members. We have the Vice Chair, David Jensaw, and Council Member Larry Hendricks, and Council Member Edward Aubrey.
Welcome to all of you. Anybody else on the plaintiff's side? Okay, how about for defendants or the interviewers? Who do we have?
Good afternoon, Your Honor. Robert Williams. I'm with the Department of Justice, Wildlife and Marine Resources Section from Washington, D.C. With me in the courtroom today is Jared Botcher, who is the Chief of the Water Operations Division at the Klamath Basin Area Office of the Bureau of Reclamation. Also here is Kristen Hyatt, who is the Environmental Compliance Branch Chief. And I believe we also have Dan Heitreck, who is an attorney with the Office of General Counsel at NOAA. Dan, are you here?
Great, welcome.
Good afternoon, Your Honor. I am Paul Simmons, representing Defendant Intervenors Klamath Water Users Association, Sunnyside Irrigation District, and Ben Duval. The counsel for the other intervenor groups will introduce themselves. I'll primarily be talking on behalf of the intervenors today. And in the courtroom today, there are a number of individuals who the water users and the other intervenors represent. And I can name the vast majority of them, and sometimes their parents, but I'm not going to try.
Okay, this obviously is a more full courtroom than I often have, and I want to welcome you all and thank you all for being here today.
Your Honor, Reagan Desmond on behalf of Klamath Drainage District, Defendant Intervenor.
Good afternoon, Your Honor. John Kinsey appearing on behalf of Defendant Intervenors, Klamath Irrigation District and Pine Grove Irrigation District. Thank you.
Great. So if everybody would have a seat for a sec. Let me set out for you what I think we're talking about today and what my perspective is on all the documents that I've read, and then I'd like to hear, I think, in the order of the intervenors, the government, and then the plaintiffs, speaking to the things that I'm concerned about. So to set the stage a little bit, the permanent injunction, which I entered about a year ago, had a couple of components. The coho salmon, which is protected under the Endangered Species Act, had significant exceedances of C. Shasta disease rate standards in 2014 and 2015, of somewhere in the 81% to 91% infection rates, and the federal government had failed to reinitiate consultation for the Klamath River Project for a new biological opinion. The law does not allow me to favor economic interests over the potential harm to endangered species. And therefore, the injunction prioritizes endangered species, the coho salmon and the suckerfish, then the federally protected rights of the tribes, and then the rights of the irrigation districts. So that's what happened a year ago. So the next thing I need to do is untangle the procedural posture of the parties' positions in this case, because my injunction was appealed. So it's up in the Court of Appeals. That typically means I don't have any jurisdiction to do anything. The irrigation district moved under Rule 60B for relief from the judgment or a stay. But because of the appeal, I don't have that kind of jurisdiction. I can make what's called an indicative opinion under Rule 62.1. So that's where I'm going to start on the pending motion. And in looking at that, the interveners didn't cite any newly discovered evidence that was in existence when the permanent injunction was issued, which is the thing that I have to look at. The argument, I think, is that there are new reports and changed water levels that make the permanent injunction inequitable. And the argument regarding the effect on family farms and ranches is a sympathetic one, as it was a year ago. But I can't favor those interests above endangered species under the law. At least that's what I found before. Those are the things that I will be interested in hearing. But I also don't think that this is a new argument that I was seeing. It's the same argument as a year ago. With respect to the federal government, the government didn't join the intervener's motion. It didn't file a request for clarification, but it asserts that it interprets the permanent injunction in a way that it would fully comply with Measure 1 regarding the winter-spring flushing flows, but forego Measure 4 because it could only achieve partial compliance. That's a very unusual reading of the permanent injunction. And I'll treat it as a motion to clarify, and so I will clarify that the permanent injunction did not limit the government's obligation to use water only from the Klamath Project water to implement Measure 1 in the first place, that partial compliance rather than non-compliance with Measure 4 would be necessary if full compliance can't be achieved, unless I modify the permanent injunction or the permanent injunction is modified. So yesterday, the federal government filed a supplemental motion reporting that full compliance is possible this year, but it's not desired because it's not effective. And the plaintiffs disagree with that. And so as I start in listening to the arguments, I'm not sure that I've seen anything that changes what the best available science is. There still isn't a new biological opinion. The government's making the same argument, again, that it made last year. And the effect of the proposal would be to benefit the interveners over the endangered species and the tribes. So that's how I'm sizing up what's been written. And so, Mr. Simons, why don't we start with you?
Thank you, Your Honor. And again, I'm Paul Simmons, speaking now on behalf of the interveners. I appreciate the court's questions so that we can help focus the arguments. And we do want to talk to the court about the circumstances of the family farms, ranches in the Klamath Project. That's why we're here. The Klamath Project is shut down right now, as the court knows by the filings. There is substantial productive irrigated land and industrious people who are idle, and their communities are in turmoil right now. That's why we're here. That's why we've asked the court to make a focused amendment or suspension or modification, stay of the injunction in part this year to redress that circumstance. Now, just again to catch the court up, part of the federal government's filing pertained to what's happened most recently. And the motion as filed asked that the court take action with respect to both guidance measures 1 and 4. The motion is now moot with respect to guidance measure 1, the so-called flushing flows. So there was an opportunity over the last several days with some storms that came in that allowed for inflow to come in below the Klamath Project and upstream of Iron Gate to help meet that amount of flow opportunistically, really, although the project still lost water. We will not, under any circumstances, have enough water this year, not under the best of circumstances. A major reason to talk to you about Guidance Measure 4 is that it has to do with timing. And the problem is, you can have all the water in the world, but if you don't have it on time, it doesn't matter. So if I were to say to the court, you'll have all the water you need for the year, the quantity of water you need, all of it. We don't get all of what we want, no matter what. But you don't get any until June. That would be a problem. You wouldn't make it to June. And that's the type of problem that we're dealing with. And I want to get straight to your questions about whether there's a basis for modification or stay or suspension. So we have identified three bases in the motion that would allow you to proceed and grant the relief. One is the injunction order itself, which in paragraphs 16 and 17 provides that the parties can try to agree upon amendments to the injunction, and if not, a party is entitled to proceed before you to ask you to modify the injunction. The other is Rule 60B. And I should say, Your Honor, with respect to 60B, we certainly agree that your action would come under Rule 62.1. In other words, 62.1 doesn't provide for us to make a motion under 62.1, but it provides Your Honor with the ability to react to a Rule 60 motion in the way that you described. And that's, with respect to the Rule 60, that's what we would request. So Rule 60 is a provision that confers a great deal of discretion on the court. It allows relief from a judgment or injunction on the grounds of mistake, inadvertence, surprise, newly discovered evidence, misrepresentation or misconduct. Applying it prospectively is no longer equitable, or any other reason that justifies relief. We believe we can check several of those boxes, Your Honor, in terms of the reasons to modify this injunction. Now, in terms of what's happened before, I'm going to focus on two. One is the premise, the foundation for the injunction was based on a fiction about these infection rates that we've talked about. And I want to describe that and how it checks several of these boxes. The second is that the injunction terms, incorporating Guidance Measure 4, that measure we now know, as we know with the first part, is supported only by the plaintiffs, not by the leading experts that the parties look to for this type of information. And we have that memorandum from the experts at the U.S. Fish and Wildlife Service, which granted was not before the court the previous time. To lead to that discussion, I do think it's very important, Your Honor, to touch on the circumstances under which the matter was adjudicated the first time, and we've pointed to this in our briefing. But recall that it was pretty quick, start to finish. We requested discovery. There was no opportunity for discovery. We requested an evidentiary hearing. There was no opportunity for evidentiary hearing on some pretty technical, difficult matters. That's all behind us. That has happened. But nonetheless, now let's come to where we are today and come to what did happen the last time around. Your Honor recited the 81%, 91% figures, infection rates, which were sometimes called disease rates or even mortality rates. And these were the foundation of the plaintiff's argument with respect to liability, but also with respect to the need for injunctive relief to deal with irreparable harm. That was those numbers. And in fact, one of the declarants for the Hoopa tribe, Mr. Ledwin. He said coho salmon are at great risk of extinction if over 80% of young fish die before they reach saltwater. 80% die, that's not good. Everybody would agree with that. And the briefing and the declarations are replete with this stuff. And there's a really interesting chart in the Yurok tribe's reply brief on the injunction on page 14. It's a very compelling table. It's document 54 in the Yurok case. A very compelling table that just lists infection rates for 2005 through 2016. And there's these big numbers, 81%, 91%. These representations and arguments were persuasive to the court. We understand that. And not only were they persuasive, they're referred to, the high infection rates are referred to as part of the reason for needing the injunction. There can be no dispute that the plaintiff's recitation of these figures was just wrong, not correct. That's not what happened. So let's talk about what they do with these infection rates. They have places in the river where they sample fish on basically a weekly basis, starting at a particular time in the spring. Let's say you sample 20 fish. You take a sample of 20 fish, and 0 show a sign of infection, 0. And then later on, you take a sample of 20 fish, and 10 show a sign of infection. That's 25% of the sampled fish, 10 out of 40. But it makes a whole lot of difference whether there were fish present or how many fish were present when this sampling took place. So, if when there were 20 fish sampled, there were 1 million present, and when or 20 sampled and 0 detected, 1 million fish present, 100 fish present, 20 sampled, and 10 had disease, were there 25% of the fish were infected? No. There were roughly 50 out of 100 million, 100 that actually had infection. The figure that you've been given, the annual prevalence of infection number, is the 25%. It ignores how many and whether fish were present at all. Now that's addressed in an email from Dr. Somm, one of the Fish and Wildlife Service experts, dated February 14th, 2018, where he confirmed, or he says to Mr. Kirby, after one of these technical conference calls had taken place, and Mr. Kirby brought it up, Dr. Somm says, accounting for the outmigration timing of the populations can lead to drastically different estimates of impacts to the populations. And he gives an example that demonstrates the point. And that's, he used 2016, and then Mr. Johnson, in his declaration, which is document 139 in the Hoopa case, 39.8, does this on a little broader scale. And he analyzes the same location that Dr. Somm did his work for. That location happens to be where fish numbers are actually estimated. It happens to be what they call the hot spot for infection, and it happens to be the area that's most potentially affected by flows from the Klamath Project. Now, Your Honor, he used data that indeed existed at the time this came before you before, from various reports from Oregon State University and the Fish and Wildlife Service, but had not been put together in this manner. We acknowledge that. Nonetheless, I believe I think that allows us to check several of the boxes under Rule 60 that I've just mentioned. Newly discovered, I mean, it was lightning fast, Your Honor. So not only that, I suggest that this wasn't fairly represented to the court in terms of what the facts of the matter are. And you're now, I think, to ask the question, is the injunction I thought was needed based on what we know now? So we have compelling facts that were not. 2014 and 2015 were not the years of highest infection even. So the premise of liability was correct. Premise of the injunction, we believe, is very weak based on just fundamental fairness that is part of Rule 60, new information that we brought together, that we provided, and the representation of that information was not appropriate. All of those are part of Rule 60. Now, the other thing, of course, is the Fish and Wildlife Service memo that is recent that relates to Guidance Measure 4, and the Fish and Wildlife Service biologists, who are the experts, really aren't buying it. And I understand the plaintiff's arguments that the fact that there's uncertainty doesn't inherently mean that an injunctive relief measure is clearly erroneous. Well, that's not the question I'm interested in. The fact of the matter is that wasn't before you. We understand that also. The Fish and Wildlife Service is not a defendant in this case. But that calls into question. They're not agreeing with this. And it goes beyond saying there's uncertainty. They also say that the fixed discharge released from Iron Gate is insensitive to discharge and spore concentrations. Triggers may not be indicative of pending disease risk. Water temperature is not incorporated into the triggers, yet it is critical to assess disease. Fundamental defects. They also say that the triggers that are based on the sum of different genotypes, one of which doesn't affect coho, basically doesn't make sense. And, Your Honor, I submit that if the tables were turned and the irrigation water users advanced argument based on a piece of scientific information in the face of that type of criticism coming in from the United States Fish and Wildlife Service experts, it would be ball game. It would be all over. It would be don't talk about it anymore. And that should work both ways. So those are the problems, and those are reasons we do check this Rule 60 boxes. It's consistent with what the injunction provides. And we haven't talked about Rule 62 itself, but certainly it allows the court to suspend an injunction in whole or in part, as long as you're not changing in a way that changes the issues in front of the Court of Appeals. We're saying don't have that measure apply for the next 10 weeks. That's what we need. Now, again, circling back, people should be working in the fields right now. There are people, they have land payments. They have taxes. They have equipment payments. They can't make contracts to deliver their crops, or they can't perform on their contracts unless they get going, their existing contracts. All of this has nothing to do with the income and trying to turn around and provide for their families, not to mention their employees' families. And it is not all about economics, Your Honor. It is about dust storms. When we had 15 years ago, it was Dust Bowl. Wildlife damage, severe socioeconomic effects associated with depression. And so it's highly relevant at a very minimum to your need to look at the equities based on what we now know with some time to think about it and to rule on the motion favorably.
Thank you, Mr. Simmons. I appreciate it. Mr. Williams.
Thank you, Your Honor. If you'd like, I could start just with a sort of update on where we are in terms of implementation of the injunction thus far. We did file a supplement in the last few days. I regret the timing of that, but it proves what a dynamic and changing system this is and how complex and difficult it is. There were some events that transpired since our initial filing that sort of overtook that filing. So, as we stand here today, Guidance Measure 1, the flushing flow, has been fully implemented to the letter of the injunction. As the court's aware, that's a 6,030 CFS flow for 72 hours. That was done to capitalize on the natural accretions from the storm event, and also because the experts in Sea Shasta thought it was appropriate to prioritize Guidance 1 over Guidance 4. I don't think there's any disagreement from the plaintiffs on that point, that Guidance 1 was really the most important measure. And that was consistent with the injunction, which gives discretion to the Bureau to time the flows. So that used about 40,000 acre feet. About 11,000 of that was borrowed from the Fish and Wildlife Refuge, plus the accretions, and then the rest from the lake. And the Bureau is still running the calculations to determine exactly how much that was. So I think a lot of the discussion about Guidance 1, as Mr. Simmons said, is moot at this point. So we're really here just to talk about Guidance 4. And the current projections on Guidance 4 are that on May 1, the Bureau would have approximately 47,000 acre feet to use for a dilution flow. And that's about 3,000 acre feet short of the full amount of the injunction. Prior to that, there's not a drop of water that could be used for dilution flow and still meet the end of month threshold in the biological opinion for the endangered suckers. After consulting with the experts at the Fish and Wildlife Service Arcata office, who are experts in Sea Shasta, the Bureau is predicting that a dilution flow is unlikely to be triggered within 3 weeks of the conclusion of the flushing flow. So that brings us to April 30. And in speaking with those experts myself, they advise it's probably closer to 4 weeks. So we don't expect that we would get a trigger for a dilution flow prior to the Bureau having 47,000 acre feet. The full 50,000 would not be available until May 20. And the duration of Guidance 4 we now know is going to be the full length of time specified in the injunction from April 1 to June 15. And I should just qualify, the projections that I've just explained are based on a 50% exceedance forecast, and that is with the project shut off until June 1. So that's sort of where we are in terms of the actual ability to implement the injunction given current hydrology. What I'd like to say next is just to let the court know we have received a notice of intent to sue letter under the Endangered Species Act from the upriver Klamath tribe on the sucker biop. And so that notice was 60 days and it just has ripened. So we may be in a situation of facing litigation, trying to raise the lake levels, which is going to further complicate compliance with the flows that have been ordered by this court. So where we line up, I think, with the defendant interveners is on Guidance 4. And particularly on the POI, the prevalence of infection metric. Now that's taken from the biological opinion, and that was the metric that was available at the time the biological opinion was written, and we realize now that there are some serious limitations with that metric. So we've heard a lot about the 81 and the 91%. Well, what is often conflated as disease rates, but it's really infection. And I think that's an important point to clarify, is we're talking about infection. And so infection does not mean showing clinical signs of disease. Infection does not mean that it's actually going to be fatal to the fish. All it says is that there is a spore identified. So it shouldn't be assumed that 81 and 91% infections means mortality of that magnitude. And what I would urge the court to look at is Table 1 from one of the original Fish and Wildlife Service technical memorandums that were provided to the tribes and that became the basis for the guidance document that was then used to craft the injunction. I can hand that up to the court. I have a copy here. It's in the record in the Hoopa tribe case, ECF 71-3 at page 80 of 89. And what the court can see is if you look there, what the Fish and Wildlife Service experts at Arcata did was they weighted the timing of the migration and the abundance with the prevalence of infection. And you can see what happens there is that the 81 and 91% figures, when weighted for abundance and timing of outmigration, become 18 and 29%. And I would also urge the court to look at figure 5 from that same technical memorandum, and that's at the same source document at page 82 of 89, and I can hand a copy of that up.
Okay.
That figure perfectly explains what happened. If you look at the figures for the years 2014 and 2015, what you see is the outmigration happened very early. And so you can see the outmigration and the abundance completely did not overlap with the disease. But because they're sampling throughout the entire season and the POI is only based on the sampled fish, it can skew very high. So the 81 and 91% figures that we sort of all took at face value, I think, a year ago, now that we've consulted with the experts at the Fish and Wildlife Service and they've explained what those figures really mean, I think that really calls into question whether this guidance document and guidance 4 and the injunction that's based on it is really the best available science.
So this was part of the biological opinion in 2013? This was the standard that everybody was looking at, and you're saying the standard was wrong based on what people now know?
The POI metric is in the biological opinion, and it's a very valuable metric for certain applications. There was not this other methodology available that the Fish and Wildlife Service has since done. But the biological opinion does use that metric. The figures are correct according to that metric, but there are very important limitations to the metric, as the guidance document that the Fish and Wildlife Service provide, and which I just referred the court to, demonstrates that it's a tool that's very important for certain applications. It's like a Polaroid snapshot of any moment in time at what's going on in the river, and it's very valuable for that utility. But when you're looking at what the effects are in terms of survivability to the class throughout the entire season, it's not. It can be very misleading, as we saw in those 2 years. If there is an overlap between the disease outbreak and the migration, then it can be more realistic and more reliable. But we can see in those 2 years that it didn't occur that way.
So one of the things that I've been a little confused about is one of the reasons we're here is that the formal initiation of consultation was triggered by the disease rates. The government didn't do that. And then a year ago, I thought what was going to happen was, in addition to completing the formal consultation, there was going to be a new biological opinion. So tell me what the status of that is.
Okay, if I could speak to that, Your Honor, and I would like to correct it. It was in dispute whether the agencies had reinitiated consultation.
They hadn't
and
completed
your order found that they had reinitiated consultation.
Right, but they hadn't completed it, and the point of it, I thought, was to come up with whatever the best current science was, and I'm just wondering what the status is now.
Sure. So there is a reinitiated consultation that's been ongoing since your order and since January of last year. These consultations tend to take a number of years. The prior biological opinions have averaged 2, 3, 4 years. This current consultation is expected to conclude currently spring of 2020. So we're looking at another 2 years under this injunction. And the reason for that is that the Bureau and NOAA Fisheries are taking a collaborative approach where they're involving all the stakeholders in the consultation. And that's, I think, a total of 7 different tribes, plus the irrigation interests. And that obviously adds a lot of complexity to the consultation and adds to the timeline. As I mentioned at the outset, there is now a notice of intent to sue on the sucker biop, so that is, I think, going to be addressed as well. The lake elevations adds another layer of complexity to an already very difficult project where things are very finely balanced. So I think it's important when we think that the Sea Shasta experts at the Fish and Wildlife Service have said that they don't support guidance measure 4, and they've provided this memorandum that was provided with our original filing, where they go through guidance 4 and lay out their concerns. And what we saw in response from the plaintiffs was, well, they're just noting uncertainty, but a fair reading of the memo that the experts provided goes far beyond uncertainty. They lay out concrete examples of where a dilution flow could be triggered and yet not be effective. And I think it's important to keep in mind when you're talking about uncertainty, I think it's one thing for the experts to say, there's some evidence to support this. We think it will work, but we're not certain. It's another thing when the experts say, we have no basis to know whether this will work, and we're so uncertain that we really don't have confidence in it, we don't support it. And I think that's where the Fish and Wildlife Service memo falls. And I think the way it's written by scientists. They're not paid consultants that are familiar with litigation, and they write in scientific terms. So to them, when they say we don't have any data to support that, that's a very telling statement. So to us, maybe as lay people, we think, well, all they said was it's uncertain, but to them that's a very strong statement. And the memo does use the word concern. They have concerns, and a very serious concern about the temperature component. And again, I think that should set off alarm bells that this injunction may not be based on the best available science. And this is not just the Fish and Wildlife Service experts. This has also been reviewed by the experts at Oregon State. So I think, the consensus among those experts is there's no evidence that this flow would work. And they say that because they've looked at the past record, and there are only 2 years in the record where a dilution flow kind of event has happened at the same time that there's a disease problem. That's 2005 and 2014. And in 2005, there was a natural event. Mother Nature just provided a lot of water, and that actually did have an effect. But in 2014, it was an artificial attempt at a dilution flow, and it didn't have the intended effect. So what you can take from that is, artificially, we just can't put enough water down the river to have a dilution flow that has an effect. It's really only Mother Nature that can provide that. So what we're talking about, I think when we're talking about guidance 4, is really just an experiment. And there are concrete examples, like I said, that the Fish and Wildlife Service has identified when it would not be effective. For example, if there's a trigger that's because of one of the sampling locations located 30, 40, 50 miles down river from Iron Gate, past the confluence of other tributaries, releasing water out of Iron Gate, by the time it gets down there, is only going to add about 9 to 18% of the volume. So it's really not going to have effect. And that's more than uncertainty. That's saying there's a circumstance, a concrete circumstance, when this could be triggered and have and not be effective. And then the other triggers that the Fish and Wildlife Service identified, the spore concentrations, Those are non-genotype specific, so we're talking about Chinook salmon, and there are certain spores that affect only Chinook salmon and not coho. So they're looking at Chinook, and there could be a trigger based on Chinook that's actually not affecting coho, and that would trigger a dilution flow, and yet it would not be effective for coho because coho may not be experiencing a disease problem. And I think that's demonstrated by last year in 2017. There was almost a trigger for a dilution flow, and yet throughout the entire sampling period, there was no fish that was detected that had clinical signs of the disease. So that shows, again, that there's a concrete problem with this guidance measure. And I think if you read the Fish and Wildlife memo, temperature is one of their greatest concerns. That's where they use their strongest language. And they say that really, if you want to know what's going to have the greatest impact on mortality, it's the extent of the infection, the severity of it in individual fish, plus the temperature. And guidance measure 4 does not account for either one of those. And that was a measure that was in the draft guidance document, but not included in the final. The Fish and Wildlife Service experts did provide comments on that, and they have concerns about the way that their comments were addressed, and they have concerns about their science being used to justify this guidance document. I think if you ask them for a simple thumbs up or thumbs down, do you support the dilution flow, they would give a thumbs down. And sort of the court asked at the outset, what's new here? Why is this newly discovered? Well, the tech memo was in the record. It was actually filed by the plaintiffs the first go around. But again, given sort of what we think were the irregular and expeditious way that this case was decided on summary judgment, nobody really clued into it. Fish and Wildlife Service was not a defendant to the case. The final version of the guidance document came out after the government had filed its opposition to the motion for partial summary judgment. In the complaints, there were claims for failure to reinitiate consultation, and then there were also substantive challenges to the biological opinion. There was a Section 9 claim for unlawful take. They didn't move for summary judgment on those. They only moved on the procedural claim. And so we thought that was really all that was in play was the procedural question about had the agencies reinitiated consultation, and if they hadn't, they should be ordered to do it. We didn't think that we were defending the biological opinion. There was no administrative record for the biological opinion. And we had asked for separate briefing on remedy. The defendant interveners had asked for an evidentiary hearing. Those were not provided. So I think at the time it would have been extremely difficult for us to have uncovered this piece of information from the Fish and Wildlife Service because I think, frankly, we're just taking the 81 and the 91% figures at face value. Just briefly, Your Honor, you had asked, why shouldn't the injunction require partial implementation? I think all the points I raised go to full implementation of the measure. And then if we're talking about only a partial implementation, there's a statement directly in the most recent Fish and Wildlife Service memo that says that type of flow would not provide the intended population level disease benefits intended. So I think they've been very clear on that point. They don't see a path.
My point was actually something different, Mr. Williams. The notion that the government's interpretation of the permanent injunction did not pass the laugh test. And when a lawyer from the United States comes out from Washington, D.C., you represent not only yourself and your credibility, but the credibility of every lawyer who stands up for the United States. And so the idea, clarifying, bringing the information that you've brought today in argument, that's good, that's helpful. But saying, I interpret this permanent injunction that I don't have to comply with part of it, and that's how I'm going to do things. That's what I was getting at. So I don't need you to go through the science of that. It's just the argument was poor.
Well, if I may, Your Honor.
I wouldn't, actually. If you have something substantive on what we've been talking about, that's a different topic altogether, and I'd be very interested to hear it.
Okay, well, I'll leave it at that, Your Honor.
All right, so who's...
Your Honor, we asked the court to deny the request to eliminate the dilution flows for 3 reasons. The first is the injunction does not allow this partial flow theory, and I won't address that any further. The second is the best available science supports the injunction, and the third is there will be irreparable harm to salmon and the people who depend on salmon without it. So I'll turn to the best available science. I think you've heard a skewed rendition of the underlying science. The biological opinion, and even though it wasn't litigated, everyone agreed it compiled the best available science up to that point in time. And it found that the disease rates and the infection rates both in the juvenile salmon are the #1 threat to the survival and recovery of this population. And that even though this parasite, C. shasta, exists naturally, the levels have been far greater than that in recent years, in this period of record, and the rates had to go down. That was decided. And, there's an infection, okay, that's one measure, but the infection then leads to disease, which leads to mortality. Not every time, but the biological opinion goes through that this is a risk. And even before there's mortality, the infections can lead to susceptibility to predation, and vulnerability to other diseases and things as well. So that I think that there's a little bit that's misleading here. We also have in the biological opinion that what the biological opinion said is things have to get better, and they certainly can't get any worse. And so the biological opinion had a 49% infection rate as the cap. Historic rates were about 30%, and then we saw 81%, 91%. This is the measure, the only measure that exists in the historic record, and it was used as a point of comparison. And the Fish and Wildlife Service memos from 2016, which went through peer review, and this court also said that compile the best available science, they had that correlation between infections, and infections can lead to disease as well. And I'd like to make one reference to the most recent technical memo, because I think what you're hearing, there's one statement that an infection isn't necessarily indicative of disease, or that the triggers for the flows aren't, because temperature's a factor. And I'll get to that in a minute. But there's another statement, and I'm going to quote it because I think it clarifies some misunderstanding. The Fish and Wildlife Service experts were responding to the water users, and they said the statement that C. shasta infection is an entirely unreliable indicator of effects to the species is a misrepresentation of the value of POI, being prevalence of infection. And then they go on to say it's an important metric for assessing disease conditions, even though there are others like temperature that will tell you mortality risk, and that it's very important for disease management. In fact, perhaps the only thing we have that we can use to say things are getting worse, we need to do something. Also, this recent Fish and Wildlife Service memo, which is different in kind than the former one, it was not meant to compile all of the comprehensive evidence and science. It was in response to questions raised by the Bureau for this motion, for this proceeding. And there were specific answers to questions in there. What the Fish and Wildlife Service experts never say is that dilution flows are ineffective. They never say that. They never question that. And nobody has offered any other kind of an emergency mitigation plan if the disease rates spike. What they've said is they have some questions, and they fall into 2 categories. One is the amount of the flows, and the other is the triggers. As to the amounts, they say there's some uncertainty. And it's important to look at what they say. There are 2 data points on record, as my colleague described. 2014 that had flows of less than 1 day, which had an effect while the flows were flowing, but then it wasn't a lasting effect. And then 2005, which had 3-4 weeks and much higher flows than what the injunction requires, which had very successful. But that's not what's in the injunction. The injunction is far less than that. And what the Fish and Wildlife Service folks said is we don't have enough data to know whether 50,000 acre-feet and the particular flows in the injunction will be effective. And they even give examples where that volume of water won't be enough. And we admit it may not be enough, but it's better than not having the flows. And there is an experience from 2012 where there were flows of 3,000 and 4,000 CFS for a period of time, and the disease rates did not spike that year. So, there's a little record. We admit we don't have a lot of data points, but nobody's questioning that dilution flows are an effective mitigation strategy.
So what do you do with the chart that either Mr. Simmons or Mr. Williams provided, which show the impact, shows the POI in 2014 and 2015 and the at 67 or 66 to 96, but at the end of the day it comes down to 18 and 29.
Do you have a copy?
Here, I'll just pass you
It
this.
was not provided ahead of time. Can I have a minute? I'd like to show it to my experts too.
Sure.
And respond in a minute.
Yeah, no, I'd be interested. I'd like to have a response.
And I'd like to address the prevalence of infection point generally before I can look at that too, if I can. So the prevalence of infection, again, it was the trigger in the biological opinion for the real-time disease flows that were supposed to occur, but they did not occur because there wasn't water set aside. And it was the limit on take. I think the statement has been made that we don't know that there are population impacts if you have 81 and 91% prevalence of infection, but we do know because we've seen the returns from those years. And the returning adults came back in among the low records that we've ever seen. So we have some proof in the real world that the disease rates did have an effect on the populations. That actually goes to the irreparable harm, because the harm then is we had fisheries closed in 2016 and 2017. And that was before your court for 2016 that was happening. There was a disaster declared for that season and one requested for 2017. Last year, the Yurok tribe didn't even have a subsistence fishery. And that has devastating effects to the tribe, to individuals who don't have the food or don't have the money for medical expenses or shoes for their kids to go to school. But it's also a fundamental harm to the tribe because they couldn't do what they do as river and fish people. They couldn't come together and teach their children to fish. And they couldn't communally catch the fish and clean the fish and smoke the fish and doing all of the things that make them Yurok people. And so we have that proof both in terms of the harm to the species and also to people who depend on them. And in terms of where we are now, we're in the juveniles that went out in 2015, and we had the measured 91% infection rates. Their children, their progeny, are out migrating now. And so we have a year class that was severely weakened that is now out migrating. And if there's another spike in the sea Shasta rates, it could devastate the survival of the Klamath Coho. So I'd like to address one other point, and then if I can confirm. And that is some of the other issues that my colleagues have raised from the Fish and Wildlife Service memo do not go to the effectiveness of dilution flows and what the amount should be. What they go to is what should the triggers be? Should the triggers be one genotype or some combination of two? Or should there be a trigger that accounts for the outbreak of the infection being downstream, where the flows from Iron Gate Dam may be too far away? And on that, we actually agree maybe the water should come from somewhere else, not the Klamath Project. The issue of water temperature has been raised. And if there is science to show that water temperature is more of a trigger than some of the other triggers in the injunction, we're ready to sit down and talk about that. But there's a process in the injunction, and that's the adaptive management process. And that's where the technical experts would look at the science and would solve the problems, would resolve them. The condition in the adaptive management provision is that there's reliable evidence to consider and that this will help achieve the purposes of the disease management flows. But what's happening here is these issues about the triggers are being used to try to jettison the flows altogether. That's not achieving the purpose, and that's putting the burden of water scarcity on the fish.
So what's your perspective on the status of the conversation between the scientists, between the people who actually know something about the issues that we've been talking about? When after my initial injunction, the idea, the actual injunction itself, language was kicked to a group of people who understood the science and tried to figure out what the right thing to do was within the parameters that I had described. You've been talking, or they've been talking, I assume, for the last year and coming up with a biological opinion. So where are they on this critical issue?
In terms of the biological opinion, we learned today the prognosis on when we might be seeing that. So those discussions have not been inclusive, but the technical experts are in constant contact, most recently about taking advantage of the rain events for the flushing flow, which eventually proved successful. They were able to come up with a change to the ramp rates for the flushing flow, which saved about 7,000 acre-feet of water. And so that was productive to use less water. There have been preliminary conversations about some of the other issues, but they haven't been presented with any kind of documentary factual information. In fact, many of these issues were presented in the first time in this litigation, rather than for the technical party. So, I mean, frankly, I think the lawyers could get out of the way, the technical experts could sit down and resolve a lot of these issues. And I can represent for us, we're willing to roll up our sleeves or have our technical experts do that and resolve these issues even in 3 weeks, to the extent we're talking about triggers and evidence that we can really dig into and solve some of the issues.
So I don't understand why that's not happening. You have people who are suffering on every side of this issue, and why the parties don't have their hair on fire to try to solve that problem is a mystery to me. But why don't you go back and find the answer to the question that I asked, and then we'll end up hearing from...
Okay, thank you.
Good afternoon, Your Honor. Thane Somerville for the Plaintiff Hoopa Valley Tribe. And I concur with the presentation that Ms. Goldman just made for the plaintiffs in the consolidated case. I wanted to stress, as Your Honor is aware, this is a dry year, and there's water scarcity in the region, and that's going to affect fish. And if there was any year to remove restrictions that are in place for fish, this would not be that year with the conditions that are going to be faced by the fish. There was a suggestion in modeling or in correspondence about a month ago that this was going to be looking like 2015, which was a year that the fish suffered a very high infection rate. And the current proposal by defendants would be to have no water at all for dilution purposes, to go back to just the flows in the biop. And we view that as very concerning and very problematic for this water year. I wanted to touch a little bit on the process that led to the court's order, because there's been some characterizations as to how that was done last year and the ability that the agencies and the interveners had to comment on the guidance document. And the guidance document in draft form was actually submitted to the federal agencies, including the Arcata Fish and Wildlife Office in November, early November of 2016, well before the briefing in this case. And all of the federal agencies, including the Arcata Fish and Wildlife Office, submitted comments to the plaintiffs' experts and consultants. And those comments were recorded in a detailed matrix that's at Appendix F of the guidance document. And that incorporates and records summaries of comments from the Arcata Fish and Wildlife Office, who submitted the technical memo that's been in discussion today. The final guidance document did then incorporate those comments, respond to those comments, and get submitted in the reply briefing. The federal government actually filed and sought leave to file a surreply after that document was filed, but it didn't discuss issues raised in the guidance document itself. Then the court issued its first order on February 8th, and it didn't just blindly say to go implement Guidance Measure 4 as written in the guidance document. It in fact directed the parties and the experts of the federal agencies, interveners, and the tribes to collaborate for nearly a month to discuss the guidance document and specifically some of these issues regarding triggers that are being discussed right now today. The parties reached an agreement and had compromises on all sides to deliver that document, which was ultimately entered by this court on March 24th. So there was a period of about 4 months where the federal agencies, including the Arcata Fish and Wildlife Office, had that document in their possession. And so it's a little mischaracterization to say that it was as rushed as the presentation that's been presented today. In addition, if you look back at some of the comments that are included in the record and included in that matrix that's in the guidance document, many of those comments present some of the same uncertainties or similar uncertainties that are being discussed today. And Your Honor, in his initial order, actually referenced some of those comments and referenced some of the federal agencies' uncertainties, yet found that they didn't preclude issuance of the injunction, that the best available science convincingly showed that there was support, scientific support for the dilution flows as well as the flushing flows. I further agree that it's a mischaracterization of the current technical memo submitted by the Arcata Fish and Wildlife Office to say that they've expressed non-support for the dilution flows. I don't think that's a fair reading of the document, and in fact I think it's a gross distortion of what that document says. They certainly do present uncertainties, some of those that have been before this court before, I believe. They do not say that dilution flows are unwarranted. They do not even say that reserving 50,000 feet of acre feet of water is unwarranted. I think a fair reading of the document may be that they think a greater reservation of water would be necessary to implement the flows as they see them having the most benefit. And as this court recalls, the 50,000 acre foot cap in the injunction that's been issued by this court was a negotiated compromise in the discussions. The guidance document doesn't set a cap at 50,000 acre feet. It says that you reserve 50,000 acre feet because that's prudent management, but then you would release those flows until the disease thresholds go down. You wouldn't just stop because you've hit the 50,000 acre foot cap. The government's, even the government's position with regard to that technical memo has shifted somewhat as the hydrology has changed over the last month and as their pleadings have been filed over the last month. At docket 145-1, which was the brief they filed on March 27th, and at that time they were arguing they shouldn't have to do partial implementation, but they could reserve 50,000 acre feet of water by May 24th. And they said, quote, implementing a full emergency dilution flow after the date of May 24th would provide the intended population level disease benefits. That was their position at that time. But then 2 weeks later, when they have enough water to fully implement it, the position has changed significantly in construing what the Arcata Fish and Wildlife Office actually said, which was that they found uncertainties and they believe that partial implementation exacerbates those uncertainties. But now we're in a situation where they can fully implement the 50,000 acre feet, and it's an unfair reading to say that the Arcata Fish and Wildlife memo undercuts the release of that full flow this year. I'd just like to echo the significant equities and public interest that my client, the Hoopa Valley Tribe, faces in this case. The Klamath River flows through their reservation as it does with the Yurok tribe. It's a people that's been fishing on the river since time immemorial, since before the project was in place. And they're facing year after year where fishing is extremely limited, if not completely prohibited. And that is a significant interest that this court must consider. And as the court has noted, your equitable discretion is restricted in this kind of a case in the ESA. But even if it weren't, there are significant equities and public interests on the side of the tribal plaintiffs and the Hoopa Valley Tribe people that support continued protection for the fish in the river.
Thank you. Ms. Goldman, do you have an answer for me?
Well, I've been trying to sort this out. I think I'm not sure the significance that table has for the discussion here, and it's presented by the lawyers. It wasn't identified by the Fish and Wildlife Service technical memo that was prepared for this case. I would say a couple of things. There's some safeguards. One is when there's 80% out-migration, when that's done, the flows would end. So if they're saying there aren't enough fish that would be infected, that would end. And if there is some serious issue here about the triggers in the injunction that is represented by this table, again, we would sit down and talk about it and do it on an expedited basis. So the door's open to those kinds of discussions.
All right. Mr. Simmons.
Thank you, Your Honor. Again, Paul Simmons for the interveners. And, Your Honor, I hope that you heard that the answer to your question is there is no answer to that question about the difference between the reported prevalence of infection on an annual basis and infected fish. We heard it again in these arguments. Fish suffered high infection rates in 2014 and 2015, the highest. No, they did not. Not the fish, the sampled fish. I urge you, Your Honor, to review Mr. Johnson's declaration. No one's disagreed with a single fact that it sets forward. It did not set forward what the Fish and Wildlife Service disagreed with. The Fish and Wildlife Service said something about what the attorneys said in the brief about this metric. So those that invented this and deploy it, they indeed say that it has utility. And the utility is that it's an important metric for assessing conditions in real time. It can inform management decisions such as timing of hatchery release, calculate parasitic exposure or dose, and it's used with sentinel studies. Is it useful for identifying the percentage of fish that are infected? No, they didn't say that. They said in that same memo that the weighted consideration for abundance is the most useful metric for considering effects to the fish population. In that same memo, they disagreed with what the lawyers wrote, that this is not of any relevance. They have it for scientific purposes. I get it. Those same purposes were used in the biological opinion. Did anyone know in 2013 that this weighted for abundance thing wasn't part of it? I didn't. There probably would have been a lawsuit then because it plainly would have been arbitrary, but it's there. It's there, sure. And there's a dilution flow in the biological opinion, and that's because that one was done back when things were collaborative, candidly, in the Klamath Basin, and people figured out there's something that plaintiffs' interests wanted. We found a way to accommodate that within the opinion, and you could use the environmental water account, but there wasn't water in 2014 and 2015 because they were dry years. The environmental water account wasn't big enough those years. But so, yeah, it's there, it's been there, but there is no answer to that question. And as we're pondering whether this injunction should be revisited based on current equities, the facts of the matter are incredibly important. The foundation of that injunction has dissolved. It has dissolved. And Mr. Johnson's declaration identifies the percent of fish that showed infection through the years that we have, and 2014, 2015 are sort of in the middle. Now, it's been said that, well, there were low returns in 2014. Absolutely, there were low returns. And returns are and always have been cyclical. And you know what? They're coming back right now. I don't know what decision was made by the Pacific Fisheries Management Council, but there are a lot of Klamath fish in the ocean as compared to a year ago. Well, how did they get there? Aren't those fish that went out in 2015? Of course there are fish that went out in 2015. Somehow they're there, despite a 91% statistic that is really, for purposes of an injunction, meaningless. With respect to the process for the Fish and Wildlife Service's guidance document, or not for the plaintiff's guidance document, so they provided it for comment, and the interveners they were in the administrative record, comments from some of the agencies, and in our response brief to the court, we pointed out, hey, the Fish and Wildlife Service has some negative comments on that. What we heard back was, that's the wrong office of the Fish and Wildlife Service. You're talking about the Klamath Falls office. It needs to be the Arcata Fish and Wildlife Service comments. Well, we didn't have those. I've never seen an actual copy of the Fish and Wildlife Service Arcata comments. I guess they were late or whatever, but now we know what they think. Now we do know what they think, and we can talk about what it says and what it means, but it speaks for itself. And I reemphasize that if the tables were turned, we'd be done here. We would be done here. With respect to the process for preparation of the order, there was an order telling the parties to develop an order. I think it's not fair to say that this was somehow negotiated. If the court had said, I'm inclined to do something with these guidance measures, go see what you can come up with, that would have been one thing. But the court instructed us.
Oh, I lay out the parameters, and
yeah,
I said,
so
I don't understand the science. The experts need to sort it out, and that's what I thought was happening.
Right, Your Honor, but to the extent that the court ordered that the order to follow in 30 days must include Measure 1, must include Measure 2, and must include Measure 4, and must not adversely affect suckers. Those were the instructions from the court. There's only so much you can do with that reality. And so the parties gave you back an order that does do that, and it only works in the wettest of wet years, we now know, in terms of not creating chaos. But, and so in that context, just so you know, the interveners in fact filed an objection to the very same order that we submitted to you, to the proposed order that we submitted to you, making it very clear that our objection was not in anticipation you were going to enter a different order, but that we'd objected to any order whatsoever. And so, just to avoid the types of arguments that we're hearing today. And it's stated that the thing has an out-migration trigger. It's irrelevant to the fundamental point that the foundation for this injunction that was issued, that was advocated by the plaintiffs, doesn't exist. And
I understand that argument.
And again, I think we checked many of the boxes in Rule 60.
Thank you.
Thank you.
Williams.
Your Honor, Ms. Goldman made a comment about the returns being low and the assumption being that that's because of C. Shasta disease in the river. If you ask the experts at the Fish and Wildlife Service, what they would tell you is that the ocean conditions play the large role there. We've been in an El Nino system that's not been favorable. Fortunately, it looks like we're coming out of that system, so ocean conditions are expected to improve. But I think it's a gross oversimplification to say, well, the returns were low, therefore it's C. Shasta. The ocean conditions play a huge role. In terms of guidance for, can it be tweaked? Can we adjust the triggers here or there? That misses the point, which is there is no artificial flow that can be done to dilute the river that would be effective. That's what I take away from the Fish and Wildlife Service's memo, and I urge the court to give that a close read. I mean, there's been characterizations of that memo on both sides, but I think it does speak for itself. But it's a fundamental disagreement on whether there should be dilution flow at all, and certainly not in some amount less than what's in the injunction from the experts. Only Mother Nature can really provide a dilution flow that's effective. And then in terms of the Table 1 and the Figure 5 that I handed up, again, there were 4 Fish and Wildlife technical memos that were provided at the request of the tribes a year ago. The tribes then took those technical memos and then they created the guidance document. The guidance document became the basis for the injunction. The table and the figure are from one of the Fish and Wildlife Service tech memos that were provided to the tribes and filed by Ms. Goldman as an exhibit to one of her declarance declarations. So it's in the record. It really shouldn't be subject to dispute. It speaks for itself and really calls into question those 81 and 91% figures that we've heard so much about.
All right, thank you. Any last words, Ms. Goldman?
The Fish and Wildlife Service comments on the draft guidance are in the Bureau of Reclamation record at 6. So they were before the court. And I can just tell you there's a lot of, the experts have a lot to say about that table and what role it might play in reinitiated consultation or sitting down that is far more than I can communicate.
Can I add one comment, Your Honor?
Certainly.
In regard to the Johnson declaration and the contention that it is unrebutted in the record, the declaration of Dr. Joshua Strange at docket 141-4, paragraph 18, does discuss Mr. Johnson's declaration and says his additional, I quote, his additional analysis and claims regarding annual infection rates has several problematic or erroneous unstated assumptions. And it's a long paragraph that I would direct the court's attention to if it's interested in that.
Great. All right. So I understand the urgency of making a decision as fast as I can, and I will. I will go back and I will read Fish and Wildlife's memo again and the other documents that have been described. The argument today was very helpful to me. It is, as I say, there is the solution, or as one of the lawyers said, the solution was to this maybe Mother Nature's, but I'm going to have to do what the law tells me that I need to do with respect to this, and I will try and do this as soon as I can. So thank you all very much. The next case, we're going to take a break for the court reporter for about 10 minutes, and then we'll start up again.